session, the Honorable Judge McEnany presiding.
Please be seated. Thank you. Good afternoon, everyone. Welcome to the afternoon session of the Court of Appeals sitting here at Johnson County Community College. My name is Patrick McEnany. I'll be serving as the presiding judge for this hearing, which means essentially that I keep track of time. That's pretty much it. I'm a former district court judge here in Johnson County, as was Judge Steve Levin, who's immediately on my right, also a member of the Court of Appeals and former district judge here. On my left is Judge Keith Schroeder. Kim Schroeder. Oh, what's his name?
There is a Keith Schroeder.
Yeah, there is a Keith Schroeder.
And he's on a
Kim.
few of our briefs this month,
Yeah,
too.
right. Kim is a former district judge in Southwest Kansas and is now a member of our court. We have 3 cases on the docket this afternoon. Each one has 15 minutes on a side to argue. We have read the briefs. We typically ask that you jump right into your argument, but because we have quite a few students here in attendance who may have forgotten what some of the background facts are from these sheets that we distributed earlier, you might take just a minute or so to give a very brief background of the facts before you launch into your argument. These lawyers know that that because we have had a chance to read the briefs, we need to get your appearances when you come up here so we'll know who's arguing the case. And if you're the appellant, we need to know whether you need any rebuttal time, and I'll try to keep track of that for you. With that, we'll go to our first case, which is case number 117198, State of Kansas versus David Eugene Sisson.
May it please the court, Nicholas David for the appellant, David Sisson. May I reserve 3 minutes for rebuttal, Your Honor?
Yes, you may.
Thank you, Your Honor. A brief factual restatement of this case. This case began back on April 23rd of 2015. At that time, a Johnson County Sheriff's Deputy, Jordan Cruz, was on patrol here in Johnson County, and he witnessed a pickup truck which appeared to have its tag light outside of the casing on the back of the truck, emitting a white light. Deputy Cruz decided to pull the vehicle over. When he pulled the vehicle over, the driver of that vehicle was Mr. Sisson. Deputy Cruz learned that Mr. Sisson had been drinking that day and initiated a DUI investigation. Ultimately, Mr. Sisson was arrested for DUI and was ultimately convicted. However, in the district court, Mr. Sisson had filed a motion to suppress evidence from the stop. He argued that Deputy Cruz lacked reasonable suspicion to pull him over based on a suspicion that he had violated KSA 81706C. Mr. Sisson filed a timely notice of appeal, and that brings us to today's proceedings.
And that statute says?
That statute says that a vehicle shall be equipped with a light which emits a white light illuminating a person's tag that's visible from at least 50 feet away. And, Your Honor, in this...
Actually, it says clearly legible.
Clearly legible, correct, Judge Lee.
So does that mean we need to be able to read all the required contents of a license plate?
Mr. Sisson's position is no, Your Honor, and that's a critical distinction in this case because the evidence presented at the suppression hearing was that the tag light was hanging down to where a part of the word Kansas on the top of the tag was obscured. There wasn't actually any testimony at the suppression hearing that the contents of the tag had been obscured to where the deputy was unable to read the tag itself, nor was there any evidence that the deputy was confused as to whether or not there was a Kansas, whether this was a Kansas tag or if it was a tag from another state.
Well, the deputy testified, quote, "The way the light was hanging, it was so bright that it was causing the reflective material on the license plate to make the whole plate so bright that I couldn't see the lettering. Then the light would swing back and forth on the cords that it was on to cause me to have more difficulty to see it." So can't the trial judge, based on that testimony, find that for that officer, at least as he was following the vehicle, at whatever distance he was at that point, it wasn't clearly legible?
Well, I would disagree, Judge Lieben, because the statute 1706C requires that a driver have a tag light which illuminates a white light, which must be legible from 50 feet away. The issue in this case is that the deputy never testified how far away he was.
I understand. My question was specific. At whatever distance he was, based on that testimony, and we'll deal with the 50-foot issue in a second, but wouldn't that testimony be enough to conclude that wherever he was at the time he was seeing it, where the reflective material was so bright that he couldn't see the lettering, and the light was swinging back and forth, causing even further problem, at that point, can we say that the plate was not, quote, clearly legible, unquote? Then we get to the distance issue separately.
Well, Your Honor, setting the distance issue completely aside,
Thank you.
I would agree that testimony that the tag light was so brightly illuminated the officer couldn't read it would render that tag illegible for that portion of the statute.
Okay, so since all we need here is reasonable suspicion, not the slightly higher probable cause or even the higher proof beyond a reasonable doubt or any other standard, just reasonable suspicion, why isn't it enough that, and there was a video of this, right?
There was, Your Honor.
The trial court reviewed that. So they had that in to figure out this 50 feet, how much different it might look at a different distance than the officer was. Why isn't that enough to give him reasonable suspicion that at 50 feet it would not be clearly legible?
Well, Your Honor, it doesn't provide reasonable suspicion under the facts of this case and under the totality of the circumstances, because in terms of 1706C, the distance of 50 feet is the core of the statute. Every tag is going to be illegible at a certain distance. If you get far enough away from a vehicle, you're not going to be able to read the tag. And so testimony that Mr. Sisson's tag wasn't visible at some distance is simply not enough. The state was unable to produce any evidence of how far away the deputy was. And in fact, at the suppression hearing, when asked directly about how far away the deputy was when he observed the tag light, he said that he couldn't recall. In fact, he was asked twice and said that he could not recall. And there was further testimony involving a capture from his body camera talking about how the videotape itself was difficult to understand, and how the deputy's view was different at the time that he was observing the vehicle. And so our position is, because of the very specific nature of the statute, even under a reasonable suspicion standard, there just wasn't enough evidence to conclude that the tag was illegible at a distance of 50 feet. There was no specific evidence presented on that when the deputy said that he didn't remember how far away he was. Let's see, he followed this car for about 2 miles before he stopped it, right? Correct. The evidence was that he followed the car for between 2 and 3 miles.
2 and 3 miles. And was he immediately, do we know, was he immediately behind this car throughout that time he was following the car?
Your Honor, the transcript of the suppression hearing was quite brief, and I don't believe it's entirely clear from the evidence that was presented whether or not he was behind the car the entire time and what distance he was at.
Would that not show on the video?
Well, it would show on the video, but there wasn't any testimony to lay the foundation for what that distance would be.
Well, if he's let's say he's following it, he's not tailgating. and he's not so far back that he can't see anything. But if he's traveling at the normal distance that one would travel behind another car at whatever speed they were going, and he says, I can't read that tag. Under the statute, 50 feet, I'm not sure exactly what this distance is, but I sure have a suspicion that he's violating the law because I can't read the tag from what I would think would be what the legislature intended. From a normal driving distance, you ought to be able to see what the tag is on the car in front of you. Isn't that enough to justify at least a stop? After all, he wasn't convicted of driving with an improper tag, was he? Improper tag light. He was only convicted of the DUI.
That is correct, Judge. Your Honor, our position would be that it would not be, because the legislature, when they enacted 1706C, did not say legible at a reasonable distance. They specifically said legible at a distance of 50 feet. And I would agree that based on the videotape, it doesn't appear that the deputy was tailgating Mr. Sisson, but I don't think it is clear whether or not he's 50 feet or more away based on that videotape, and there was no foundation in the testimony to show where it was that the deputy was in relation to Mr. Sisson's vehicle. And so our argument would be that that's simply not enough given the specific nature of the statute.
Don't we have case law that basically says even if the officer made a reasonable mistake of fact as to what the law is, that is still reasonable for him to process and proceed with the stop?
I would agree.
I think that comes out of North Carolina from the Supreme Court.
I believe you're referring to North Carolina v. Hyen, and
Right.
Your Honor, I would agree with that statement. However, that was not raised by the state at any point, and there's never been any argument that Deputy Cruz had made any sort of reasonable mistake of law.
I'm not saying that he did, because I mean, there's no dispute that the tag light was not attached to the vehicle as it was originally. Is that correct?
It was hanging down from its enclosure is what the evidence was.
All right. And so the question is was it reasonable for the deputy to then think that the tag was defective? The tag light was defective when it wasn't attached in the normal way to illuminate the tag.
Your Honor, our position would be that it was not reasonable for the deputy to believe that, because the thrust of the deputy's testimony was that it was the word Kansas at the top of the tag which was obscured, not the actual tag number. And there was no testimony at the suppression hearing that would suggest that there was any sort of confusion that this was a Kansas tag. And so the purpose of the statute is to ensure that the deputy could read the tag and understand.
When you're talking about the evidence that it just obscured the word Kansas, wasn't that evidence the picture that was Exhibit A from the defense?
It was, Your Honor.
And that picture was taken while the car wasn't moving, right?
Correct.
So in the officer's testimony, while the car is moving, the light is moving back and forth. And in the excerpt I read, it was causing the reflective material to make the whole plate so bright I couldn't see the lettering. And then it would swing back and forth, which gave him more difficulty to see it, according to his testimony. And the exhibit you're referring is one where the car was stationary and the light's just hanging right then in front of part of the word Kansas.
Your Honor, that's correct. However, my reading of that testimony was that it was swinging in front of the Kansas lettering, obscuring only the top portion of the tag, which...
But what about the part of the testimony that said it made the plate so bright because the plate itself is reflective that it made it impossible to read or difficult to read? Whatever his words, well, he said, so that I couldn't see the lettering.
Well, if we're excluding the issue of at what distance it was that occurred, I would agree with that. However, we have, these issues of facts which are intertwined.
Sure.
And causes an issue of whether or not that was sufficient evidence for the district court to reach the conclusions that it did, which were that the tag was illegible at a distance of 50 feet.
Right, I guess I was just, you were making the argument that I think was based just on this one exhibit, Exhibit A, the picture of the light in front of part of the letters, but that's taken when the car is stationary. That's all I wanted to be sure that was what you were basing your statement on.
That is correct, Judge Lieben.
Thank you.
And so I'd like to also touch just briefly on the community caretaking stop argument which was raised by the state. Your Honor, this is not a case which could be justified as a community caretaking stop, and the main reason for that is the holding of the Supreme Court in Marks, which is that a public safety rationale cannot be utilized as a pretext for an investigatory detention. And in this case, Deputy Cruz very clearly testified at the suppression hearing. He was asked, did Mr. Sisson, did you witness him commit a traffic violation? The answer was yes. Did you pull him over for that traffic violation? The evidence was abundantly clear that this was an investigatory detention, and so the community caretaking rationale would not be available under these circumstances. And I would touch just briefly.
Just so everyone understands, when you talk about community caretaking, that would be an instance where, for example, the cop's driving down the road and he sees a car ahead and the wheel is wobbling like the lug nuts have come loose and the wheel's about to fall off the car. And he says, whoa, stop these guys, tell them that their wheel's about to fall off so they can correct it and avoid an accident. That's the kind of thing that would involve a community safety kind of thing?
Yes, exactly, Your Honor.
Well, and you don't need to resort to that if, in fact, there was evidence, or at least reasonable suspicion, that there was some sort of a traffic infraction.
That is correct, Your Honor.
Alternatives to justify a stop.
Correct. And in order to prevail at this stage, the court would have to agree that this stop was justified by neither reasonable suspicion nor community caretaking principles.
Right.
So, Your Honor, unless there's any further questions by the court, I don't have any further presentation.
Well, you still have your rebuttal time, counsel. Thank you very much.
Thank you.
May it please the court, Sean Minahan for the state. What the defense attorney has argued here is basically facts. These are factual arguments that are best left to the district court judge, who is there to hear and see the testimony of Deputy Cruz and see and hear the testimony of David Sisson. Judge Cameron was there to view all that and to make a determination on credibility and ultimately whether there was reasonable suspicion to stop the defendant.
You're not arguing at this stage that the stop was justified for public safety reasons, are you?
Yes.
You are?
Yes.
Let's hear all about that.
Okay, I'll tell you about that. Let's say
There wasn't a wheel about to fall off or anything, was there?
Let's say you're driving down the road and a light flashes in your eyes and you think that a car's coming directly at you. That was what Deputy Cruz testified to, is when this light was flashing back and forth, it looked like a car coming at him.
In the wrong lane.
In the wrong lane. And so I think that, and there's a reason.
And obviously moving away from him.
Yeah, but
Backing up down the road at a
yeah,
high rate of speed.
But it's still, there's a reason why we have taillights like that.
Sure, but
And if it's blind, and it also was, he said it was blinding.
And it took him 2 to 3 minutes to decide that it was enough of a problem to pull him over?
Right. And so, you know, you can't win all the facts. But there is a danger of some vehicle having a bright light that's hanging off the back of it and blinding people who are driving behind it. As to the reason,
to make that work more typically, you'd also have a defective taillight problem, wouldn't you? Because if you've got a light there, but you also have 2 taillights illuminating on either side of it, that kind of would lead you to believe maybe this isn't a headlight after all.
right, but it also could, and, you know, I think the deputy's testimony was also that it was blinding him. And I think a reasonable person.
In your brief, where you put the defective light was a safety issue at page 2, you quote the officer as testifying that he stops people a lot of times for this and they thank him to let them know they've got a problem with their car. You don't cite at page 2
Where it says that?
under the safety issue on page 2.
Okay.
This is your brief, right? That's talking about you say, cars don't always say you have a tail light or a brake light is out. People always have a nice reaction when I'm like, hey, your brake lights are out, it's not that big of a deal, just get it fixed. People would always be appreciative of that. That's the testimony you cite for the safety issue.
Right, and I think that he was trying to explain that this was a, when he sees a situation where there's a safety issue, like, tail lights out and things like that, that he will stop a person and just let them know, hey, your tail light's out, you need to go fix it. So that's why I was citing it there, but if you look on, and I think this is volume 10, let me make sure.
Are you in your brief?
No, I'm just looking at my notes. Volume 3, page 14, he talks about the bulb, the entire simile was hanging out, which reason being it looks like a headlight's coming towards you in your lane of travel, which causes safety issues. That's page
You
4.
do have that on page 6 of your brief, although you don't have it in your section on public safety.
All right. But I think this
but-
court has to consider the entire record in their decision.
Okay. I'll have to admit, I've never seen the white light hanging out, but I in front of a plate, but if it was a white light hanging out right over the license plate at that level, I think I'd be able, and I had brake lights on either side of it, just up above, I think I'd be able to figure out pretty quickly it wasn't a headlight.
Right.
But did Justin...
But it also is flashing in your face too, which isn't helping you drive.
I understand. Did,
You're talking about swinging, not flashing.
Yeah. As it's swinging by, it flashes him, and
I have to agree with Judge Lieben. I have a hard time understanding how the tag light, which is very small, would be as bright as the headlights, which are generally very big, when you're looking at it going down the road.
well, it's a bright white light,
Oh, I know
and
what it is.
tag lights aren't white; they're red, right?
No,
And
your tail lights are
right.
red,
Well, that's what I meant. The tail lights are red,
but your tag light is generally white.
white. Yeah, so it's going to be brighter than the tail lights, and
Right, but I'm just trying to say, I have a hard time with the depiction that it's as bright as a headlight.
oh, as a headlight.
As a
Oh,
headlight.
okay, I got you. That's what.
I mean, that's a factual
did
statement.
Judge
right?
That's
Cameron
what deputy-
find this was a danger by it being too bright or looking like a headlight?
She made a finding, something about the bright light. Let's see.
She found that,
On,
that the word Kansas was not visible on the tag and the light was very bright, and it did appear to be defective in that you couldn't read a part of the tag.
yeah, and I think she also says in the beginning that it was quite obvious which car he was pointing to because as it drove by, it had a bright light, something to that effect.
Did she make a finding, one way or the other, on the community safety issue?
Yes. Yeah.
What did she say about that?
I'm already back in.
She said it hindered his ability to safely read the tag.
No, when I'm talking about this, that has to do with the, the tag light, possible tag light violation. I'm talking about public safety of confusing drivers into thinking there's an oncoming car.
Let me see in my notes if I said something about that. I don't, here it is. It's on, her findings are on volume 5, pages 11 through, 10 through 11, it looks like. No, it doesn't look like she specifically, well, in my notes, it doesn't say that she specifically identified that. She had,
If she didn't find for you on that and you're complaining of it now, didn't you need to file a cross appeal?
I think you have to consider the whole thing to determine reasonable suspicion
But,
and public safety.
but we aren't going to review de novo whether or not it was are we?
Well, if the court is right for the wrong reason, then this court can address the issue.
But if we would not accept your community safety rationale, do you have any other basis for us to uphold the trial court ruling?
There's certainly reasonable suspicion. Anytime you're dealing with reasonable suspicion, there doesn't have to be facts on each element of a potential offense. And here you have Deputy Cruz testifying that it obscured the license plate. And he even says in volume 10, pages 28 to 29, that even at 2 feet away, he can't read the Kansas part of it. And he also testified that as it's driving down the road, it's going back and forth flashing him, but also flashing the license tag, causing it to...
On Exhibit A, how much of the Kansas is obscured?
I don't remember exactly.
How many letters do you think? Is the K obscured?
Yeah, I'm trying to visualize seeing it.
I mean, that light can't obscure all the letters of Kansas, could it?
No, but, that's an important part of a license tag to determine whether, what state it's from.
Isn't it? We only have 2 states that start with K.
All right.
We can take judicial notice of that.
But,
And this one also ends with S. And if the K and the S aren't obscured, then that's pretty much a technical argument that doesn't go anywhere.
But you have to keep in mind that this was a light that was hanging down, that was flashing at the license plate. And so although it was stopped in A, it may only be obstructing the middle section of Kansas as it's going down the road, going back and forth, flashing the officer, and then flashing the, oops, sorry. I don't know why I'm sounding sorry. Flashing,
apologize to
yeah, I apologize. Flashing the license tag, which illuminates, that's how they build them. You can't see anything on there. And so the fact that, defendants A shows that it only obscures ANS or whatever isn't really relevant to whether he had reasonable suspicion to pull him over because he can't read it. So, unless this court has any other questions.
I guess I'm agreeing with you. I think it's more significant whether he can read the rest of the plate than it is whether part of Kansas is obscured.
Yeah, I would agree with that. I would agree with that. All right.
Thank you.
Thank you.
Counsel, you have your rebuttal time.
Thank you, Your Honor. I would start by just clarifying the court's question on the exhibit. In the exhibit, the bulb is seen hanging just partially over the letter N in the Kansas tag. It is not, I would argue that it's only obscuring at most 1 letter, perhaps 2.
When it's stationary.
Correct, while it is stationary. And as to the community caretaking argument, I think it's best for the court to actually look just to what the testimony was on that. And in volume 4 on page 15, Deputy Cruz was asked about the public safety issue, and his testimony was, it's stating it's a public safety issue in general. I'm not saying that that was exactly the case here, but I'm saying all of those facts go into why I stopped the vehicle. And the follow-up question was, so it wasn't a safety issue in this case, and his answer was, it could be in other cases. And so, Your Honor, the deputy's testimony was very clear that this wasn't a community caretaking stop. There was no bona fide safety issue in this case, that he was stopping the vehicle for another reason. And with that, unless there's any further questions by the court, I would waive the rest of my rebuttal.
No questions. Thank you, counsel.
Thank you.
Take the matter under advisement and get you an opinion as soon as we can. Our next case is number 117162, State of Kansas versus Christopher Michael Dale.
May it please the court, Peter Meharry for Christopher Dale. I could reserve 3 minutes of my time for rebuttal, Your Honor.
Yes, you may.
Thank you. As far as a quick factual background, this case goes back to August of 2009. It involved an incident at a skate park in Olathe, Kansas. Several individuals were at the skate park, Mr. Letowski, Shellac, and Mora. They were approached by an individual by the name of Rickerson, who attempted to sell them an iPod. There were some words exchanged between the two. The testimony was that Rickerson wanted to fight. The other three individuals declined and then went off on their own business. Rickerson called his cousin, Megan Clark. She did not answer the phone, but my client did, Mr. Dale. Rickerson told him what occurred. Megan Clark and my client then went to the park. My client also brought his pellet gun. Once they were there, Mr. Dale and Mr. Rickerson went up to Letowski and Shellac, if I'm pronouncing that right, put the gun to the back of the head of Mr. Letowski.
This is a pistol, I take it.
It's a pistol, Your Honor, a handgun. It's a pellet gun. Puts it to the back of the head of Mr. Letowski.
The fact it's a pellet gun's not important, is it?
Not for the issues we're dealing with today.
Right.
But put it to the back of the head of Mr. Letowski. At that point, I think the testimony was Mr. Shellac got up, he pointed it at him, and in the process of pointing the gun at those two individuals, Rickerson took several items that were on the ground next to those two, 3 cell phones and an iPod. From that, my client was charged with 2 counts of aggravated robbery dealing with Letowski and Shellac, and then a 3rd count of theft dealing with the theft of a cell phone that belonged to Mora. Mr. Mora was in a different part of the park when the incident occurred, so that was brought as a theft charge. After a jury trial, my client was convicted of all 3 counts. It came up to this court on appeal. This court reversed because of instructional problems with the aggravated robbery instruction. Once it went back down to the district court, Mr. Dale filed a motion asserting 2 issues, and those are the issues that we have raised today. The first issue was that this court reversed the aggravated robbery convictions, but it affirmed the theft conviction. And Dale argued in the district court that affirming the theft conviction barred prosecution for those aggravated robbery charges, asserting that the theft was actually a lesser included offense. The second issue that he brought in district court was that the 2 aggravated robbery charges were multiplicitous, and that it was 1 act and the state could not divvy it up the way it did into 2 charges. The district court denied both those motions and allowed the prosecution to continue. They agreed to a bench trial. After the bench trial, he was found guilty of both aggravated robbery charges, and also there was an agreed upon sentence after the conviction. On appeal, like I said before, we have brought the same 2 issues that were raised after remand by this court.
Let me stop you and just partially for our audience kind of redefine what the issues are in the case. You used the word multiplicitous.
Yes.
And we talk of charges being multiplicitous when, under the double jeopardy clause, you're essentially getting tried twice for the same crime.
That's correct, Your Honor.
So all this is really a double jeopardy issue, but in our case law, we treat it with this multiplicity term.
Yes, Your Honor.
Okay. So had there only been 1 trial, we have a little bit of an issue here because we ended up with 2 trials.
Correct.
Had there only been 1 trial, and we later decided that some of the charges were multiplicitous, they were the same act being charged more than once, our remedy would be just throwing out some of the convictions, but we usually throw out the lesser crime, not the higher crime, right?
That's generally the case, Your Honor. Obviously, in this case, it's a little different because what we're arguing is multiplicitous are the 2 aggravated robbery charges. So they are, I guess, equal crimes, not a lesser included.
Well, but you're also arguing, your whole point on your first issue is that the theft charge for which he was already convicted and affirmed in the first trial is multiplicitous to the ag robbery charges.
Essentially, yeah, the two issues certainly do bleed together. I
But
think
that's the basis for your first issue, right?
well, the first issue is that the theft was actually the lesser included offense. And under the Kansas statutes, you can be charged and convicted of the crime charged, the lesser included offense, but not both. And it's our contention that all of the charges arose out of the same act.
But had he been tried at one time, the claim would have simply been that it's a multiplicitous charge.
As far as whether or not after the first trial, whether or not that would have been the
No,
claim.
if you'd only had one trial.
I'm not sure. I think that
Well, it
the
seems
way
to me the only reason you're able to raise the issue you're raising is because your client and his attorney didn't raise it the first time around.
I guess I would disagree with that. I think that certainly if this court would have addressed the issue on the first appeal,
But it wasn't raised.
it wasn't raised. But I don't think that impacts our ability to raise it now.
But I'm not arguing that, but if you had had a conviction on all three charges in trial one, and rather than having an instruction issue raised, you had raised the multiplicity issue, the remedy at that point would have been to throw out the theft conviction, leaving him with the ag robbery conviction, wouldn't it?
I'm going to make a little bit of a distinction, because our argument is, in that situation, our argument would be that you'd throw out one of the ag robbery convictions and the theft conviction, because we are arguing.
Well, that's your issue two.
Right.
Right, but
so-
just as to issue one, the remedy, as between one of the ag robberies and the theft, you'd throw out the theft and still have a conviction for ag robbery.
That is how the court handles it in the past, yes, Your Honor.
Okay, so what I don't understand, and this is my real issue here, we aren't here with what we call res judicata, which means some judgment has become final and we're bound by it. We're here with what we call the law of the case doctrine, meaning we already decided in Appeal 1 that the theft gets affirmed. We sent it back for another trial, but the case is still going. Now we've had the second trial, we've got conviction for the theft and the ag rob. Exclude the second ag robbery conviction for a moment. And just dealing with issue one. We're in the same position we would have been had we gotten the first appeal, this issue raised. So if law of the case is a somewhat flexible doctrine, which we say, why should we not put him back in the position he would have been in had he raised this in the first appeal, instead of waiting until Appeal 2 to raise this issue?
Well, I don't, just the way the case is postured, I don't think you can do that. I don't think you can look back and say, well, this should have been raised in the first issue, and we're going to put him in that position
What
for the
case
second
do you
appeal.
cite for the proposition that we can't do that?
I don't know that I have a case that says that, Your Honor. I don't know.
Case you have that we shouldn't do it? I mean, is there any case in the briefing that addresses that question at all?
Not that I'm aware of, Your Honor. I think the court should not do that, simply because I don't think the court should basically judicially create a situation when you're basically ignoring what actually happened. What happened here was he did appeal. He did not raise this issue. That's not contested in any way. But I don't think the court should sit there and say, well, he should have, and because he should have, we're essentially going to punish him for that. I don't think that's the court's position. I think the court has to look at what actually happened, and in this case, the issue was not raised. And in the subsequent trial, which when this court remands it back down for aggravated robbery charges, you're kind of starting over with a new trial.
Of course, you really didn't start over because there was no new evidence. You basically, instead of having the second trial being a jury trial, you said, Judge, we're going to let you decide it. And how are you going to decide it based on the evidence presented at the original trial? Here's the transcript that you decided. There's no new evidence presented.
And the jury instruction error turned out to be a complete red herring in that you went back down and didn't have a jury trial. That's perfectly the choice.
I'd
The
say that's
judge in
their
the first
option.
trial retired, new judge is there, make the decision, try it to the court.
And that,
That's
and
perfectly
certainly,
fair.
you know, they have that option to do that. As far as the second trial, I would say there is somewhat of a distinction because they did, I believe, I can double check the record, they did also look at the preliminary hearing. So there was a little bit of different evidence. And you still have a district court making a decision based upon that evidence. So I still think you have, you know,
Just
this
saying
wasn't a
we
show
say
trial.
Trial in quotes in a certain sense.
I disagree with that. I think you still have a judge saying you're
you're
guilty
right.
of aggravated robbery. This is not, you know, a trial in a moot court competition. This is a real trial where my client got convicted.
And I do agree. I'm pretty sure you're right that the prelim testimony was admitted as well.
So, you know, when you go back, my client, even if he didn't raise it before, can raise it now. And I don't think this court should ignore the way this case got before this court for a second time. And for law of the case, it's relitigating issues. We aren't relitigating issues.
But law of
These
the
are-
case is not a binding doctrine.
It is not a binding doctrine,
And
what
we
it,
wouldn't be relitigating the issue either, would we? There was nothing wrong with the theft conviction, but now that there's an ag robbery conviction, it's multiplicitous. What are we relitigating?
I don't think we are relitigating anything. That's why I don't think law of the case applies.
Can I ask you about, on issue 2?
Sure.
There we're dealing with this multiplicity test with respect to 2 aggravated robbery convictions.
Correct.
And let me be sure we're agreeing on the test here.
Sure.
The first part of the test is we have unitary conduct, meaning it's the same act
Correct.
or sequence of acts that are well-connected.
Yes.
And then the second one is, what did the legislature intend the unit of prosecution to be?
Correct.
In the FAM case, which you have cited, the court had some language, although it is dicta in FAM, suggesting that you can have a situation where there's more than one victim and more than one aggravated robbery charge.
When I look back at those cases, I think, and I hope this come through in our brief, I think what the focus needs to be on to determine whether or not you can go with one egg robbery or multiple egg robberies is the number of takings. And I think when you look back at those cases, the FAM case, they took it from one individual, whereas several of the other cases, they're taking property off of multiple individuals.
Right, like FAM cites to the case of State versus Jackson, which is from the court in 1975, and it was a prosecution for the aggravated robbery of a drugstore. They took property from drugstore employees and a customer, had 3 counts, and they said, while arising out of one transaction, they involved 3 separate takings of property and were properly charged as 3 separate crimes.
Right.
And that was cited in FAM,
Correct.
so why would that not apply here?
Because I think when you look at that case, the Jackson case, what they talk about, as I read the facts, was they took property from 3 separate individuals. It was, give me your property, give me your property, give me your property. And I think that's distinguished from what we have here, where while we have 2 people, we just have the property one spot, and it's just one taking. They're not saying, person A, give me your stuff, person B, give me your stuff.
But it's an aggravated robbery because of the use of force applied against a person. And he put the gun to Adam's head, and then he pointed the gun at Kyle when Kyle got up to try to interfere with him robbing Adam. So we've got 2 different victims that he takes a separate act of force to keep them out of the way so he can then grab the stuff and go.
But I think when you look at the unit of prosecution, I think you should focus on the taking. When you look at the aggravated robbery, I think the key part of that and what separates it from an aggravated battery and aggravated assault is the taking of property.
But when we deal with aggravated battery versus aggravated robbery, though, another thing we deal with is, in the aggravated robbery case, we look at the perception of the victim as to whether a deadly weapon was used or a dangerous weapon. So here, a pellet gun can be considered a deadly weapon while you're committing the crime, whereas in an aggravated battery case, it might not be a deadly weapon because it's in fact just a BB gun.
Correct.
So,
but I don't think that is what this court, when it looks at the unit of prosecution, I don't think that is what the court should focus on. When I think you
I'm
look
just
at
saying, in the robbery case, the act of force is the thing that makes it different than the theft, And we look at that very specifically in a number of contexts when dealing with ag robbery.
The force is what separates it from theft, but I think the core of the statute is still the taking. That's what makes it the robbery.
What you're saying, I got the impression you're saying it's not a case where I'm taking from A, taking from B, and taking from C.
Right.
It's, I'm really, but actually, he's not taking from any one person in the sense that one of them's got all the cell phones. Aren't they all lying on the bench? They're sitting at a park bench. Cell phones are on the bench, puts the gun to their head, to two different people's heads, and then scoops up the cell phones. Isn't that? Your analysis,
yeah.
It almost sounds like it's not really aggravated robbery at all because it's not taking it from as if it had to come taking it from their person.
Now, it certainly can be off the person or presence. And
Right.
here the facts are that the items taken were just kind of laying there together.
In the presence of both these
In the
victims.
presence of both of them. And the point I'm trying to make is it's not an individual taking to each individual. It's one taking in the presence of both of them, and I think that's where you only get one aggravated robbery charge. One thing, and I don't know if the court hasn't asked me, but it seemed to imply that this was unitary conduct. I do want to make a couple points about that. Number one is I certainly think the facts show it is unitary conduct. The state has argued on appeal it is not. They conceded that fact at the trial court level, that this was unitary conduct, and I think they should be stuck with that on appeal rather than changing their position once it gets in front of this court. So when you have unitary conduct, obviously the next step is the unit of prosecution, and it's our position. Hopefully I've made it clear that the unit of prosecution is based upon the taking, and even if that is in the presence of multiple people, that's still one taking to support one aggravated robbery charge. Had there been multiple takings, had he taken something out of the pocket of Letowski and then taken something out of the pocket of Shellac, arguably that's two aggravated robberies, but I don't think that's the facts that we have in this case.
You've well exceeded your time, but I'll give you your rebuttal time.
Thank you, Your Honor.
I did help you.
Yes,
Thank you.
you're not alone in this. And I'll give the prosecutor a little more time if he chooses to use it.
Good afternoon, Your Honor. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas in this case. Christopher Dale committed 2 counts of aggravated robbery when he separately forced his gun at Kyle and Adam at the skate park that day. And the district court's upholding of those 2 counts was appropriate, and it shouldn't be reversed.
How should we figure out what the unit of prosecution is, just to go back to the issue we were just on?
The unit of prosecution for an aggravated robbery should look primarily at how the victims were treated. Judge Lieben, you mentioned earlier how the victim's impressions or perception of an event is relevant in an aggravated robbery or an aggravated battery. It absolutely is. A unit of prosecution in the aggravated robbery context should examine primarily how those victims were handled. If, for instance, it was more than one person, but somebody stormed into a room and simply said, I've got a bomb, I'm going to blow the place up if you don't all hand over your stuff, and so put it all in a pile and he takes it, maybe we've got a case where there's one there because it's one general theme or one announced threat or one announced use of force. But here we have separate uses of force by the defendant against each of the 2 victims of the aggravated robbery. Had the second victim not intervened and tried to stop the events, it would have only been 1. But here we have 2. And the reason why I say that the victims should be the primary subject of that examination for the unit of prosecution is because if we're going to instead use opposing counsel's argument that the number of takings should control, that is a principle that is better applied to a theft. And that's what the case law shows as well.
What case stands for that proposition?
In Pham, when Chief Justice Nuss was reviewing the unit of prosecution in a robbery, he talked about the gravamen of the offense, The gravamen of theft is a property offense. It's the taking of property without authorization. The gravamen of a robbery or an aggravated robbery, though, is not about the property or about the taking. The gravamen of a robbery is the use of force that is applied to another person.
And he says that?
He says the gravamen of the offense is that it is a person crime rather than a property crime.
Do you know where that is?
It is in the ballpark of 1251, 281 can 1251 in FAM, where one transaction can support more than one count of aggravated robbery. Even if this court rejects the state's argument that there was...
He's got that part that says, as mentioned, a synthesis of these four cases demonstrates that under proper circumstances, one transaction can support more than one count of robbery.
Right. And so that would be one taking or one transaction could constitute
Where
more
does
than
he
one.
talk about the gravamen of it is the use of force?
I did not write down a pin site
Okay.
in my
I'll try to
notes.
find it. Thank you. You believe the word gravamen is in there, though?
I believe it is.
Okay.
Or actually, here, it may actually be in Hood, where they talk about the gravamen of theft is a property crime, not a person crime. If we had multiple counts of theft here, if he had not pulled out the gun, if instead Christopher Dale had stormed up on these two young men, 16 and 18-year-old men sitting on the bench, and scooped up their property, said nothing to them, never pulled out a gun, and the state attempted to charge multiple counts of theft, I think opposing counsel's argument would be stronger, because a theft is about the property, it's about the taking. But that's not the scenario that we have here. What we have here is force being applied both to Kyle and Adam. And when it was done, there was an intervening event, the second victim standing up to the defendant and attempting to stop what was going on. There wasn't even just one intervening event there, because the gun was first pointed at the first victim and he was forced to the ground. The second victim then tried to intervene and stop, and he had the gun pressed to his chest. And then they scooped up the property. And then the first victim, who had been forced to the ground, then tried to get up and intervene a second time, and he got smacked in the face with the gun. So we've got multiple efforts, multiple uses of force against these victims in Mr. Dale's efforts to steal their property. And so the crux of this offense, what separates robbery and aggravated robbery, what makes it higher on the severity scale and everything else, is that it is a person offense first. That's the crux of robbery. That should be the unit of prosecution. The reason why the state raised the issue of the law of the case is, and
Before we get to that, what about the unitary conduct?
the unitary conduct.
Didn't you fail to raise that at the trial level?
The state did concede in so many words that it was the same conduct.
Right.
True. I was not that attorney.
But that doesn't change anything, does it?
I think I can still present a different aspect of the argument here. I don't think I'm necessarily tied to the words that the ADA chose when he was arguing the
Not just
motion.
words, it's conceding that it's unitary conduct.
True.
That takes it out of the picture altogether, doesn't it?
I don't think it does when this court is doing a de novo review of the issue as to whether or not these charges are multiplicitous. I think this court, in its de novo review, is examining the entire record to see whether or not these offenses merged or were one, or if they were separate offenses. And when you review the facts of this case, I think you find that they did occur when we look at the four factors as to whether or not this was unitary conduct or same conduct. We look at, did it all happen at the same location? Absolutely it did, conceded. Did it all happen at the same time? Arguably it did. A few seconds off in terms of the amount of force applied to different people, but it was in the same sweeping motion, arguably. But when we talk about the other two factors, was there an intervening event? Was there something that freshly motivated the defendant to act differently as he proceeded. There absolutely was a fresh impulse or an intervening event that came about when the second victim stood up and tried to contest the taking of his property. That's what separated this. That's what moved this from being one aggravated robbery of the first victim and made it two aggravated robberies. Had that victim not stood up or not intervened, or for whatever reason had Christopher Dale not pointed his gun at the second victim, we would be here with only one aggravated robbery. The reason why the state raised the law of the case argument, and I attempted in as many words, keeping it as concise as possible as I could, I recognized in the state's brief the law of the case doctrine. It's a flexible doctrine. It generally is used to prevent relitigation of the same issue. So if Mr. Dale had lost on these issues in his first trial, had he raised multiplicity and lost, and then he was retried for other reasons, and then he raised multiplicity again, the argument would be the law of the case prevents him from doing that. That's a settled issue. But the reason why the state raised the doctrine is we are not here on this second review of this case with any different or new facts than what would have been available on Mr. Dale's first appeal. He had been convicted of all three counts at that time. He never raised the multiplicity argument or the lesser included offense argument for the theft. So that issue should be considered settled on this case. This case was not remanded for further proceedings consistent with the opinion that the aggravated robberies were reversed. So on the first appeal, the aggravated robbery counts were reversed because of instructional error. But another panel of this court didn't simply say, send the case back to district court for more proceedings. Specifically, this court said this case is remanded to the district court for a new trial on the aggravated robbery counts. That was the mandate, and that's what was performed. That's what the district court did. Although the district court, before proceeding to that trial, did review the issues that Mr. Dale had raised for the first time when it had been remanded. So the law of the case doctrine, in seeking to prevent this piecemeal litigation, should call out somebody who tries to raise these new issues when a case is remanded, and these are issues that were not raised the first time. I believe I've covered why the two counts of aggravated robbery should be affirmed and not found multiplicitous, but going back to the first issue that was raised by Mr. Dale, the theft in this case was not a lesser included offense of the aggravated robberies. And the reason is the state specifically charged it to prevent just such a scenario. When you look at the complaint, when you look at the jury instructions from the first trial, the subject of the theft was not the property of Kyle or Adam that was taken, the two victims who had guns pressed to them. The subject of the theft was the cell phone of the third individual who was elsewhere in the skate park at the time. He could not be the subject of an aggravated robbery because he had no force applied to him, or he didn't have the property taken from his presence. So that cell phone that was in the pile of property that was Austin Mora's cell phone was the subject of the theft. That count was affirmed the first time through. It is not a lesser included offense of either aggravated robbery because it does not share the elements of that aggravated robbery. The aggravated robbery specifically addressed the property owned by Kyle and Adam that was taken.
So
with force.
you're telling me if a person had come through and picked up 3 cell phones at once, confronted nobody, he could be charged 3 times?
I don't think he could be charged 3 times with 3 counts of theft there necessarily. And the reason why there is because then we are going to be talking about all the unitary conduct in the unit of prosecution. If somebody steals 4 candy bars from the grocery store, I don't charge them with 4 counts of shoplifting.
So you're saying the unit it steps outside of being unitary because there's 3 owners?
Right. There's separate owners that have, and the theft and the aggravated robbery have elements that the others don't have. The theft has the element of it being Austin Mora's property. The aggravated robberies have the additional elements of force being applied, and the subject of those aggravated robberies was not Austin Mora's cell phone. It was the property, the cell phone, and the iPod of Kyle and Adam. So.
Thank you.
I don't know how close I've come to my time.
You've
but
got a few minutes left.
Okay. I feel I've covered.
As I tell or I should have told everyone, we don't penalize you if you don't use all your time.
Well, thank you very much. On that note, if the court has no further questions, what I would ask this court to affirm both of the new convictions, in fact, all three of Mr. Dale's convictions and sentence in this case.
Okay, thank you, sir.
Thank you.
Rebuttal?
The only thing I wanted to mention with regard to whether or not the state is tied to this idea that when they concede unitary conduct in the district court, they should be tied to it on appeal. I'm never the trial attorney, but this court always holds me to what the trial attorney does. As far as objections, as far as issues raised below, I don't think it should be held differently for the state that they can say, well, sure, the DA at trial conceded, but I'm a different district attorney on appeal, and I'm not.
He's saying that's a sub-issue. We disagreed on the overall issue, and we can still disagree here on the overall issue, and we don't necessarily have to have all the precise contours below that, right, the same. That's what he's saying. So, and I can tell you, I'm not going to hold people to a different standard on the prosecution side because they have somebody new, and we hold you to a higher standard because you're here all the time as the new side. You get the same standard. But as I understand his argument, it's that this is only a sub-issue, so we're not really bound. We didn't have to cross-appeal.
I disagree with that when you get up in district court and say we concede this issue.
Well, it's a sub-issue. They
It's a
concede the
sub-issue,
point.
but it's certainly relevant and important to the overall issue. If the state concedes an element on appeal and then tries to contest it, or concedes an element at trial court, can they contest it on appeal? I don't think so.
Well, you can in many areas if it is only on undisputed facts or one of those exceptions. They haven't argued for one of those, so. Let me ask you about this last point he made on the theft charge. And as I understand his point is, the theft as charged involves both a different victim and different property than either of the aggravated robbery charges, and therefore they can't be the same. So my question to you is, I know Hood said theft is a lesser included of aggravated robbery, and we have a couple of our cases unpublished that are saying that, but I don't know that we have any cases finding theft a lesser included where, as is true here, both the property alleged to have been stolen and the victim are different.
And I'm not aware, and I can't point the court to any case that specifically that's saying that. But what I would argue to the court, and again, the two issues kind of bleed together a little bit. I think when you're dealing with lesser included, as well as to some extent multiplicity, we're dealing with one taking in this case. They took all the items at the same time. And there are cases out there where they say that even if, and I think the state conceded this, even if there are multiple owners of the items taken, that doesn't automatically mean you get multiple theft charges. So I think the focus should be on what was taken, and they were all taken together, and you have that one act. And we don't believe that from that one act, the state should be able to divvy it up into multiple charges as they did here. I don't have any.
So, I don't recall, but was the sentence in these concurrent or consecutive?
After the second trial, all three counts were run concurrent. If there's nothing else, we would just ask this court to reverse as we've argued in our brief. Thank you.
Thank you.
Thank you for your argument. We'll take that under advisement. For our last case for this afternoon's docket, it's case number 118090, Paula Luberts versus For Life Weight Loss Centers, Inc., doing business as Slim for Life. For the appellant.
Good afternoon. Michael Stipetich for the appellant, Paula Luberts.
Say that again.
Michael Stipetich.
Thank you, sir.
May it please the court. like to reserve 5 minutes for rebuttal.
Yes.
Summary judgment is only proper in a Kansas Consumer Protection Act case alleging deceptive or unconscionable acts only when...
Can I just, before we get started, are these, is his mic on in the sense of not just going to a video feed, but also in the room? Are you all able to hear him?
Okay. That mic's
Scratchy
kind of...
throat as well.
That's, I understand.
I'm just trying to make sure the mic is working.
The mic's kind of pushed away from you, so if you just bring it up a little closer,
Sorry.
that's quite all right.
I don't mean to throw you off, but I want to be sure people have a
Totally
chance to hear the
understand,
argument.
The appellant's argument is, it can be summed up by just one sentence. Summary judgment is only proper in a KCPA case alleging deceptive or unconscionable acts only when there's no evidence of deceptive or unconscionable conduct, and that's not true in the case at hand. And to briefly go over the facts for the audience, the appellant, Paula Luberts, saw an advertisement for a weight loss program, the Slim for Life program, and she made an appointment, attended a consultation with a manager who she described as talking very rapidly. They went over her health history, weight loss goals, and the appellant learned that the program would actually cost $400. And
And why did what was the reason for changing from 200 to 400?
well, as shown on the receipt, the plan cost $374 plus tax, but there were some products included. Now, the appellant does not recall taking any products home with her, although they are shown on that receipt.
All right, you've in your brief, you've said that she didn't take anything home with her after receipt of the starter, but her testimony is she doesn't recall.
Sorry,
So,
Judge.
so why would you argue that she didn't take something home when she in fact testified she did not recall, and the receipt lists item by item what she took home for the $400 including tax?
The argument was based on the appellant having recalled other details of the conversation, and that she, had she taken them home, she would have recalled that it would be obvious that's something that she would have recalled because she had a very good recollection of that conversation. But the appellant, we concede that that's a weak point. We're going to concede that.
No, but I guess I'm confused, though, as to why you would argue that she took nothing home, but yet she testified she doesn't recall. It seems to be, for lack of a misstatement of the facts. Am I getting something wrong here in your argument?
No, perhaps a better statement would have been that she did not recall taking any products home.
Well, to overcome the summary judgment, you've got to show that there is a genuine issue of material fact that's yet to be resolved, and that we need to wait for the trial to resolve those facts.
Correct,
So can you just give me a list of what are the facts that you contend are still in dispute that we need to wait for the trial to resolve, rather than pulling the plug at this early stage by granting summary judgment against you?
Right, Judge. Well, I think the most important material fact that we see at issue here is, whether the appellant knew that, or I'm sorry, not whether the appellant knew, but there was a June 3rd purchase subsequent to this initial consultation, and it was her testimony that she was not aware that she would have to purchase supplements and food products costing $2,600. and that was never disclosed to her during the initial consultation. Now, I understand that there's a program contract that does state at the bottom of that form that she'd be required to purchase 2 boxes of supplements weekly. But after attending a group meeting with other participants, they were all split into individual meetings, and she met again with that same manager who made statements such as, you'll look better and you'll feel better if you purchase the most expensive package, a $2,600 package, which contradicts the agreement, saying that she only needed to purchase $9 to $15 per box. So even assuming that the appellant, took the products home after the initial consultation, and she knew that she had to purchase $9 to $15 boxes weekly, a material fact at issue is that she, she didn't know, or whether or not she knew she would have to purchase them in bulk after that.
Well, did she have to purchase them in bulk, or could she buy them by the week?
Well, she was, according to the agreement, she could buy them weekly.
Is
But
there any evidence in our record that says that's untrue?
it is her testimony that she was told she had to buy them in bulk,
Told she had to, or told that was the best deal?
that she had to, in order to meet her goal weight.
When I look at the list of items that you're complaining about, the additional charge for $2,640,
Correct, Judge.
when I look at the list of items, I see that many of the items selected were by power of choice. Whether she bought a chocolate plus protein, a cinnamon splash, or caramel crunch bar, wild berry passion. Those seem to be items of choice that she could choose to buy or not buy.
I don't believe that there's any evidence in the record showing how the choices were made as to those particular items.
Well, how about the whole sheet? I mean, what does the evidence say about her choice to what she bought for supplements in order to reach her goal to lose weight?
I'm sorry, are we talking about the?
I'm talking about the $2,600, because that's one of your primary
Right.
allegations.
Right.
That's
Those were, it was, we would argue that the items were selected by the representative, not by her, not by the appellant.
all right, but what did the testimonies show?
That the items were boxed up for her, and
They just give her this box and said, you owe us $2,640?
honestly, Judge, there's no evidence I can think of in the record showing how they were selected, just that they were boxed up for her.
Now, she signed for and paid for these,
Yes.
so she had the power of choice to do so?
She did, although the KCPA states that there can be violations whether or not a consumer is misled. But we would argue that it's certainly a deceptive act to not advise a consumer during initial consultation that they would have to purchase a much higher cost set of items.
You told us initially that one of the facts in dispute that needed to await the trial was whether or not she knew she would have to buy more stuff. And you're saying she says, I didn't know I had to buy more stuff in this program. Now, we have some documents. There's a guarantee that says prices supplements are not included in the guarantee there. They are an additional cost, non-refundable, non-exchangeable, and she signed an acknowledgement that she's required to buy supplements. And the price sheet says supplements are required part of her program and not included in the $400 price. Now, if you go to trial and those documents are presented, what would be your evidence from which a reasonable juror could conclude that this was deceptive practice? That she really didn't know that she had to buy more stuff?
And you're referring to his evidence that's in the record?
Yeah, this is evidence.
No, I mean, the evidence he would give in response, you're saying, is evidence from our record?
I'd like just to know what's in the record now. Yeah, what's in the record now that would support that?
Well, Judge,
Or even you want to go beyond that and say what you'd produce at trial that would show that there was a...
we're relying on her testimony alone, that she was told something different in the initial consultation, that the supplements, the food products were not discussed. And
But she testified she didn't remember whether they were discussed, right? She didn't testify directly, there was no discussion of supplements. She testified, I don't recall it.
correct.
And go ahead and answer his question, I'm sorry.
We would rely on that, you know, that the program agreement states that, you know, the products could be purchased weekly, and that you know, she wouldn't have to purchase them all in a lump.
So are you saying that if she'd have purchased them weekly and they would have cost her more, that would have not been a violation of the KCPA? I mean, I'm having a hard time following you because
Right.
her starter agreement says, I understand that the nutritional supplements and products that are a required part of my nutritional program, but they are not included in the program price except for the starter pack. And she signed this.
And she's still going to argue that, you know, that she doesn't recall that. She's gonna argue that the manager was, you know, she spoke very quickly and, you know, persuaded her into this program, and that the parole evidence rule, we'll argue, does not apply, because whether or not she signed a contract that doesn't vitiate any material omissions or untruths, and we are going to rely on her testimony that she did not recall.
So if she doesn't recall, how does that controvert the facts before the court?
There's no evidence in the record, no deposition testimony that, you know, that she was told. All we have are the documents. Now, she also submitted a application for a refund that was never processed, and she writes on that application that she thought the program was going to cost $199, and that she thought the products were going to be optional.
Doesn't the both receipts that she signed for her credit card statement state clearly, for health and safety reasons, all products are non-refundable and non-returnable?
Right, and the appellee also has a refund policy. One of their representatives testified that they provide about four refunds per year. So clearly, they do provide refunds despite their policy. Despite the non-refundable language on the documents.
Counsel, you're just about up to your rebuttal time. If you want to save your rebuttal time.
We'll save the rebuttal time, sure.
Good enough.
Thank you.
Thank you.
Nothing
Thank you.
further.
Good afternoon. May it please the court, Tom Franklin for For Life Weight Loss Centers, Inc. I believe the court has already referenced 3 of the documents that Slim for Life considers very important in this transaction with Ms. Luberts. The first document would have been in volume 5 of the record at page 202. That's a breakdown that I think that one or more of you has already alluded to that tells you the price of the program you are purchasing based on the number of pounds that you're trying to lose in the months that you're going to come in.
Can you explain to me the difference between our argument for $199 and $400 in the price of the program?
As I recall her submitted deposition testimony, she said she heard a commercial on TV. All right, so many of us watch television, see commercials, and sure, on there it might say that you can get a program for $199. When you go in, it doesn't mean that the program you pick and want to buy is the same program that's referenced on the television. And that's why on this page 202 of the record, it tells you your total program cost based on weeks that you're going to devote to the program. And there we go from $799 down to $374. And Your Honor, you already cited to the language in there that signed by Ms. Luberts that says that there are 2 things you're going to buy in addition. Nutritional supplements, which is different than products. Those are all of those food products that you pointed out on that receipt signed for $2,600. There's a further explanation of some of the supplements over here where the check marks are. There are things like vitamins and then something they call EFAs, essential fatty acids.
Is there anything in our record that tells us what the check marks mean on this document?
That means in your, no, to answer your question specifically, I don't remember if they specifically explained the check marks. You can see that there are some that weren't going to come. This is your starter pack here.
I don't know.
Right,
I mean,
right.
I'm trying to find out what our record will tell me about this document so that I can then assess whether there's a material issue for trial. If somebody thoroughly explained this document in our record, but I think our main testimony in this record is from the plaintiff.
It was.
Not from your side actually explaining this document.
And I don't think the plaintiff, when she deposed the defense witnesses, asked about these documents. I also point out that in the weight loss service guarantee, there's a specific reference to you buying boxes of supplements weekly. At page 17 of the appellant's brief, it appears that we have some level of focus as to what the complaint is here. And I pick up there where it says, by verbally failing to disclose the additional products, supplements, and food product. Well, when you have signed 3 different one-page short documents that tell you you're going to pay for nutritional supplements and products in addition to the program, and on a weekly basis, then it seems to me that what the plaintiff has presented us with here is, the plaintiff says, I'm here, yes, I signed these 3 disclosure forms that explain everything to me, but look, I claim that when you were talking to me that same day on the side, you verbally failed to disclose that I was going to buy supplements and food products. And the
Counsel, if in terms of it being deceptive, if you've got an overall program that costs $374 plus tax, so it's about $400.
right.
And you then came in a couple weeks later and said, it's going to be $20,000 for you to buy the supplements. That might be deceptive because you've already gotten the 400 in hand, and it might be that just about no reasonable person would want to buy the supplements for $20,000, particularly if you could buy something similar somewhere else for much less. At least on a theoretical basis, could that not be at some level deceptive?
Well, I don't think that's our fact.
I understand that. I'm going to get to our facts next. I'm just going to say, if we're looking to see, can you have a deceptive claim, when what you do first is say, you got to pay us $400, and I want you to notice all these check marks here that say, you're going to have to buy some more stuff, keep that in mind, but this is a $400 program, and then you find out the other stuff's going to cost you $25,000, that'd be a pretty big deal.
But
Assume for the minute that that might be a deceptive practice under our act.
you don't have to buy, let's take supplements and let's take food. I mean, if I go to the grocery store and push the cart down the aisle, and I'm really enticed by all the Ben & Jerry's, and I walk out with $1,000 of Ben & Jerry's, that's my decision about how to spend my money. That's not necessarily true about what it's going to take for me to lose the weight and use the supplements.
Here's my question, though. If you accept the idea that at some level of later price that's not disclosed versus initial cost, it might be a deceptive practice. We have here an amount, the $2,600, that once she thought about it, Ms. Lubberts thought, man, that was way out of line. I should have never done that. And I'm trying to figure out in these documents that I've got with a bunch of check marks that I don't know what they mean, have we really eliminated any possible jury question about whether a reasonable jury would say this $2,600 was out of whack when our documents talk about a couple of boxes of supplements weekly on 2 of the 3 documents with no price, and then on the other one we have 2 marked out and 3 written in, but we have $10 to $16 per box. I mean, it seems to me it might well be that a reasonable jury would come back and say, at some level this is deceptive. How do I decide this is, as a matter of law, not?
Well, probably the first thing I'd point out that there are 10 listed causes of action in the pretrial order. It's causes of action 7 and 8 that are addressed to the June 3rd purchase, and those are under the unconscionable statute and not under the deceptive statute. And the only claim that I could find...
Well, but she, if I understand it right, she's claiming that the original contract was deceptive because these later really high costs, from her viewpoint, were not disclosed when she signed the original $400 contract. That's what made it deceptive to her. I don't see how that makes the June numbers irrelevant to her claim.
I think if a company writes that I understand nutritional supplements are required, but they are not included in the program price, you have disclosed you're going to pay more money. You are going to control your own future on how much more you spend.
Well, I don't know if she's going to control her own future if she has a particular weight loss goal, which everybody's agreed to going in, and you're then telling her to achieve that goal, you need to buy X amount of product, and you've already got her committed to that goal in writing in a contract that she's already plunked down $400 for. And in fact, all of this sales pitch was strong enough that she plunked down another $2,600 buying all the stuff up front, then found the stuff didn't actually work for her for physical reasons and wanted out and didn't get any refund. And she wasn't just buying 10 to 16 per box. She bought $2,600 worth.
Of food products, candy, supplement. I mean, it was the sweet side of life that she bought for $2,600. That was a choice she made. Nobody deceived her, is the position of my client, about you're going to have to pay more if you bought more stuff. And that's what, at page 17 of the brief, they don't really contest that she got disclosure documents. The complaint at page 17 of the brief is that when they were having other conversations that day, you verbally failed to disclose additional products. But our point is, if you make a written disclosure, we have some policies in Kansas that if you're in a situation, you have to consider on the whole what happened on that occasion. And when there are written documents involved in the transaction, those control over allegations that are over non-written documents. And I'm going to refer here to a case that I'm going to admit's not in my brief, Zering versus Driscoll at 339 P. 2nd 57, page 59, that discusses that policy under Kansas law, that if you are looking at a transaction and there's a written document involved and oral statements, you look at the transaction as a whole, and to the extent that the written part of it appears to be clear and controlling, it's going to be looked at as the controlling item over allegations about non-written events.
In this one document you referred to, I don't know what you call this one, the one with your heading, it says, I understand that the nutritional supplements and products are a required part of my nutritional program. Is there anything in the record that explains what that means? Does that, in other words, is she compelled to spend a certain amount of money on these supplements? Or is it that if you don't buy this stuff, you're not going to reach your goal? Or what's the explanation of that?
You have what that's what I refer to as the pricing sheet. Okay. There's also the weight loss guarantee, which is in volume 1. It's at page 23, part of the answer. If you look on there, it says you'll buy 2 boxes of supplements weekly and you'll take the herbs. So it does, there is a section in here that's disclosing supplements at a limited level that you'll buy weekly.
On this other sheet, though, it has the 2 crossed out and it marks 3 boxes.
That's your starter pack.
Well, I don't know.
Yeah.
I just know it says 3 boxes of supplements. It was written in 2 and then it was crossed out in 3.
Right.
So I don't know how I know that's the starter pack instead of something else.
We didn't get to that point in the evidence.
Well, having signed up for this program, is she exposed to liability if she said, okay, I've committed $400 to this program, and now they're pulling a switcheroo on me and saying I've got to buy all this $2,600 more stuff, and the way I read this, I'm required to. Does that mean they're going to sue me for $2,600 if I don't buy this stuff?
I don't think there was any contention, as Judge Levin was pointing out. There's nothing in the record suggesting that there was any claim here that she was being accused of having violated her contract. She actually
No, I know,
quit.
but as far as the
She went ahead and bought the stuff.
pressures that, the pressure on her to buy the stuff, I mean, is the implication from this that you're required to buy the stuff? If you don't, we're going to sue you for breach of contract because she signed it.
Yeah, I saw no sign of anything like that in the record. She wanted to quit and get her money back.
Well, that's what she wanted after she bought the stuff and had a reaction to some of it, according to her.
After she went home, hid it in her basement, and her husband found out, she was afraid her husband was going to find out.
That's our record?
I believe that's in the record.
I thought her testimony in the record was that the reason she wanted out of the program was a physical reaction to the product she ate or drank on the first day.
There's some of that in there. There's a lot of things in the record. I didn't know that we needed to sort that out. We're taking
Well, we
the
have to figure
position.
out whether there's an issue for trial. So the facts are important.
I understand, but we think the facts are she signed written disclosures, and her claim is that she didn't get disclosures. And the only way she gets to a claim that she didn't get disclosures is to ignore the written disclosures and go with the claim that there was a verbal failing to discuss this with her. And we think you don't get to parse your disclosures into two piles. The written disclosures that you signed up, and then the conversations you had at the same time, and you say, well, I'm going to ignore the written disclosures.
I think you're about out of time, counsel.
So I guess I go back to my initial, I'm sorry.
No, go
Go
ahead.
back to my initial question. Was there in fact an ad that said you could come into this store for $199?
That's the record, as Judge Liebman points out. She did testify that she saw, I believe she said she saw a television commercial.
But that's not, but is there anything in the record that says that that's a correct statement of what the TV said? What she saw on the TV?
I'm probably not following the question.
Well, does Slim for Life have an ad on TV that says, come see us and lose weight for $199?
Your appellee accepts that she gave that testimony, and so that's what
You're not controverting that fact.
we can on summary judgment. We didn't offer different.
I mean, you could say, here's an affidavit from our ad agency. There is no such ad. I mean, but you're not.
We could have. We didn't go there because we go with the pricing page that where we gave you the best estimate as you came through the door of what it was going to cost you, $374. So, and you signed.
With the understanding that she had to buy additional supplements and products.
But I mean, you're there, you're at your point of choice. You get a written disclosure and you sign and say, I got it. So you knew what your program cost was for the program you picked.
Thank you very much. Thank you for your argument. Rebuttal?
Just wanted to point out a couple additional things in the record. In rebuttal, the appellant did testify that she believed that as of the time she paid $400, that she believed that that was the only payment that was required, that there was nothing else needed to be purchased. And when she applied for the refund, submitted that form, her testimony is that the manager, Ms. Williams, stated that, sort of backed off on the products, stating that she could get the same benefits from buying Weight Watcher dinners. So we also included, in the brief we discussed, the additional deception as to the benefits and characteristics of the products. And I think that that's a fact issue for the jury as well. And as to Mr. Franklin's argument on the contract, there is, in addition to the Osterhaus versus Toth case discussing the parole evidence rule, there is another case, Schneider versus Liberty Asset Management, not cited in our brief, holding that consumer doesn't waive any KCPA claim by signing a contract. In that case, it was a real estate contract, but there's also a statute in the KCPA stating that consumers cannot waive any of their rights under the Act. And just a quick argument on unconscionability. We do believe that there was unequal bargaining power here. Some of the conduct occurring after the transactions, after June 3rd, there are disputes as to those facts. The frequent daily phone calls that the representatives made with the appellant. She had asked 3 times before submitting the refund application to be let out of the program for a refund. And the refund application form itself shows that it wasn't submitted to the company's advisory board until a year and a half later. So with that, we ask that the summary judgment ruling be reversed and remanded. Thank you.
I have a quick question.
Sure.
On page 19 of your brief, you make a reference to our Supreme Court addressing the Wiley decision in the Via Christi case.
Correct?
Well, I've looked at the Via Christi case, and I have been unable to find the Wiley site. Did you by chance make an error in that site? It's on page 19 of your brief.
The 10 unconscionability factors were in the Wiley case. 1 second, I'm sorry, Judge.
You make a cite in reference to page 521 in Wiley, Via Christi.
Correct. And the 10 factors in Wiley were cited in Via Christi. And what was the question again? I'm sorry.
You say they were cited on page 521.
May have been an error. Judge, I do not have the Via Christi case in front of me, but
And you're confident that Wiley is cited inside of Via Christi?
yes, Judge.
All right. Thank you.
Anything else, counsel? Thank you.
Oh, no, thank you.
Thank you for your argument. We'll take that under advisement and get you an opinion as soon as we can. That concludes our afternoon session. We have a bunch of other cases that are not argued that we have to decide along with the cases that we've heard today on this docket. But before we do that, we want to give you all a chance to ask any questions that you might have about the, let's stay away from the cases you just heard. You're not going to get any brilliant insights from us about how those cases may come out. But if you have other questions, about our court, about cases in general, about the legal system, now's your time. Now's your chance. You got us in a corner. We can't get out of here. Any questions? Yes, sir. I'm sorry, who?
Ganeski.
Oh, sure. Well, if he wants to answer it.
Mr. Dale, do you know if he's completed his sentence?
Oh, actually, don't ask that question because we can't, we're not able to learn. We could leave the room real quick, but yeah, we don't want to know anything that's outside our record about the actual case. So I want to be sure we're sticking with just what's in our record for us. Sorry.
Any other questions? We got a bunch of legal scholars here. They know everything there is to know about these issues, and we can't fill them in on anything. If there are no further questions, then we will be in recess, and we thank you for coming. We thank you for your attention. We hope you learned something about how the system works. We always look forward to coming here on an annual basis so that you can see the court in action, and I hope if you're here next year, you'll take advantage of it again and see another panel of our court come back and address some new cases. Thank you very much. We're adjourned.